Good morning, and welcome to the October Intellectual Property Breakfast Club. We're glad to welcome you here this morning, day after Columbus Day, and grateful that we have a great panel here who will be speaking on our topic. My name is Drew Clark. I'm the publisher and chairman of BroadbandBreakfast.com. We're a news and events company focused on broadband, the Broadband Stimulus National Broadband Plan, and intellectual property. We actually have been doing the Broadband Breakfast Club for 3 years now, and the Intellectual Property Club is our latest breakfast series. We got involved in this because of the connection with broadband and all of the issues which copyright and other forms of intellectual property are impacted by the internet. And today's discussion is no exception. We're looking at finding solutions to problems of copyright infringement by and through the internet, and we've got a great panel to speak to these issues. But more important than the panel speaking to the issues is the interaction of each of you and these experts here. And I will invite you all to weigh in and truly have a dialogue here and just get my attention, and I'll be roaming with the microphone to get your questions in this engaging debate. Let me call your attention also to our survey form for this event. If you could, sometime during the event, fill this out. Feel free to indicate other topics that are going to be of interest to you. We have coming up in November a continuation of this. We'll be talking about approaches to piracy by internet service providers around the globe. We'll also be talking in December about China and intellectual property, and we'll have the Chinese Embassy's intellectual property attaché, Fu Li Qin, on December 14th. So mark your calendars for all of these events. Now, to get to our panel, on my left is Howard Simons, who is a chair of Mintz, Levin, Cohen, Harris, Golovsky, and Popillo's communications practice, and is really the go-to person on telecom and cable policy issues, has represented these industries before Congress and regulatory bodies for more than 30 years, and served as senior counsel to the Subcommittee on Telecommunications in the House. Was, of course, involved in the Cable Act of 1984 and other legislation since then. Next to him is Adam Eisgrau. Adam is the president of Eisgrau Business Alliances. He worked with Senator Frank Lautenberg and then became Chief Judiciary Committee counsel to Senator Dianne Feinstein. He was very involved in the P2P United, which was defending the Grokster case before the Supreme Court, and I'm sure he'll have things to tell us about the aftermath of that. But we're here today to be able to speak to what kinds of solutions are out there, what kind of fresh thinking is available on problems of copyright infringement. Next to Adam is Mike Zanis, who's the Vice President of Public Policy for the Interactive Advertising Bureau. And as the head of the Washington, D.C. office, he manages the interactive advertising industry's legislative, regulatory, and policy-making agenda. And we may actually start with Mike because he can speak to the things going on in the industry right now on the issue of how advertisers are and publishers are being more conscious of where their ads end up. He also worked at the U.S. Chamber of Commerce, where he worked on privacy, data security, and intellectual property issues. And then, last but not least, we have Lee Knife, who's the executive director of the Digital Media Association. Lee's responsible for all aspects of DIMA's business and been involved in copyright arbitrations, involved in the sound recording and music composition royalty rates. He represents a very diverse group of companies and their music media divisions at Digital Media Association. So he'll be able to speak as well to these perspectives. So let me go ahead and start with you, Mike, and tell us a little bit about the industry, the online advertising industry, and what challenges they face when it comes to surveying, policing, and dealing with the issues of copyright infringement.
Sure, thanks, Drew. Sounds like this is working pretty well. I appreciate it. If you're not familiar with the IAB, which most of you probably are not, we represent sellers of online advertising. That means the websites that actually sell advertising. So you have marketers in this space who spend money with advertising agencies who then place ads on publisher sites. That's where the IAB comes into play, and we represent digital players from the big digital natives that you may think of, like a Google, Yahoo, AOL, Microsoft, but also to the social networking sites like Facebook and MySpace, traditional media companies, the CBS's, NBC's, Disney's of the world, newspapers and magazines as well. So I think from our perspective, obviously content is very important, and we represent most of the major content companies, including studios and increasingly some of the folks from music industry as well. And what we realize is that without content, compelling content and services, you're not going to have the traffic. Without traffic, without consumers online, advertising doesn't matter. It doesn't generate any revenue. So I'd be lying if I said that we've been sort of forerunners in this or early adopters on intellectual property as an industry, but I think increasingly as we mature as an industry, we understand that we have to protect the content that's out there. And frankly, marketers don't want their ads to be displayed on illegitimate sites. And so that can be file trading sites, illicit content sites, terrorist sites, pornography sites. And so as an industry, what we realize is that we need to sort of clean up our own ecosystem to the extent possible. That's going to be good for not only the content companies, but also for marketers. And ultimately, what's good for marketers is good for publishers, including advertising networks. So this has come about in a number of ways, but I'll talk specifically about a document and a program that the IAB stood up about 4 months ago called the Network and Exchanges Quality Assurance Guidelines. What that is we've worked with our European counterparts who have had a program in place for a couple of years, trying to make sure that there's a high level of trust and quality in the ecosystem for advertisers. Because, as I said, a marketer, if you're a marketer, you obviously don't want your ad to show up on an illegitimate site. But there are also more intricate issues. If you're Toyota, you don't want your ad to appear next to a horrific car crash story. Adjacencies like that, just practical realities. And you also may not want it to be on a site talking about something bad about a Toyota recall. And so trying to make sure that marketers have quality assurance in their purchases, in their media buys, is really key. Now, it's a long document and it deals with a lot of issues such as adjacencies and discrepancies of ad reporting. But for today's context, the important aspect is that the networks, the advertising networks, which collectively, they deliver about 90% of all the ads that are displayed on the internet. They really are a big part of the economic engine. And virtually every major site has what's called a third-party advertising network that helps them fulfill the ad requests that they receive. Because if I'm a website, even the New York Times, will have too much traffic. It's a good problem to have, too much traffic to their site, so that their internal sales staff actually can't handle that volume and do direct sales. This is something Drew and I were talking about. He does direct sales on his site. He used to have ad networks because it's easier, but you want to sell as much of the advertising yourself because that's what we call premium space. The rest of it is what we call in the industry as remnant space, but it's not like going to a carpet store, right? Where somebody buys a roll of carpet and there's a little bit of remnant and it's kind of you make a little area rug out of that. In the online space, the remnant is actually the vast majority of all ads that are displayed. So the networks got together and they decided then, including a lot of other things, but they wanted to make sure that they weren't serving ads into illegitimate sites. So we included things like illegitimate peer-to-peer sites, sites hosting illegitimate content, And again, this is a business-to-business document. It wasn't meant to be brought to Washington, D.C. or codified, but it was a business-to-business document where we'll actually categorize the inventory, so the pages.
Let me jump in on that, Mike. So how long has it been easy for a publisher to say, or an advertiser to say, I don't want my ad to appear on X type of site, a site that has pirated or infringing materials on it?
Those types of provisions have almost always been part of contractual relationships. Literally every ad online is governed by what's called an insertion order, and usually you'll say as a marketer, I don't want to be on certain illegitimate sites. The reality is when you're serving 100 billion ads a day across the ecosystem into tens if not hundreds of millions of sites, just to give you an idea, it's estimated there's a little over 1 million sites domestically alone that sell advertising. It gets really hard to police that ecosystem. And I won't even get into the complexity right now of what an ad exchange is, but the reality is it's not just that Microsoft serving ads into hundreds of thousands of websites delivers an ad to an illegitimate site, a known illegitimate site. That's fairly easy for Microsoft in this example to police and say, we're not going to serve into this particular domain. But the reality is they may serve it into an ad exchange and it may go through a series, handed off by a series of companies before it actually gets delivered to the consumer. So it's not easy is the answer, the short answer to your question, but it's something that the industry is committed to making stronger.
In other words, even if the publisher says, I don't want this on Pirate Bay, it could end up there? Is that what you're saying?
It's possible, and again, it's because what you may have is you have a marketer then places a buy with a legitimate ad network like Microsoft, and the consumer is down here and they go to piratebay.com, and what happens is somewhere in the ecosystem there may be 4, 8, 10, 20 redirects back up to the original ad delivery. That's where it becomes tough to police. Microsoft wants to do the right thing, and they're not going to serve ads into that domain, but at some point in the supply chain, they sort of lose control.
Well, let me just jump to you, Adam, and when you were representing P2P United, how important was advertising revenue as a business model for these peer-to-peer companies?
Significantly, I think, but that was in a relatively early stage of the, excuse me, the development of the technology. Clearly, the folks and sample members of P2P United would have included Grokster and Streamcast, which ran Morpheus, and several others. LimeWire was an initial founding member of the organization. So they weren't in business as charitable institutions, and I think although P2P United was a Washington arm of that industry designed really to sort of tell the story of where it came from and where they hoped to go, and to, although I don't know that it was believed by the majority of folks on Capitol Hill, it was the truth nonetheless that we were interested in trying to be part of the new emerging business model or models, along the lines of what Mike was just describing. So in terms of the overall objectives of the industry and what it was predicated upon, the allegation, which was ultimately accepted effectively by the Supreme Court, was that it was predicated upon the theft of intellectual property, to use the words of the plaintiffs in the case. But that really wasn't the objective, certainly, of the organization. And just to give credit where it's due, the litigation before the Supreme Court was not something that I had the privilege of participating in directly, but it certainly was germane to the fate of the organization, since the tenure of P2P United ended more or less with the drying of the last dot of ink on the Grokster decision. So.
Well, do you have anything to say about what's next? I mean, has that decision made any impact on the popularity of such sites?
By my observation, which has been that of sort of the highly interested layperson over the last couple of years, not a hell of a lot. I mean, we're still having largely the same discussion about control over a technology and a medium and its popularity, which I think it's fair to say history has shown to be pretty much uncontrollable. That's not an argument for copyright infringement. It's not an argument against intelligent and balanced enforcement. It's not really anything except a pragmatic recognition, which was another pillar on which P2P United was founded, of the fact that disruptive technologies are called that for a reason. And you can either figure out what you're going to do with them, even though you don't particularly like what you may have to do with them, or you can, in some instances, at least during the tenure of the organization, stick your head in the sand and attempt to litigate your way out of it, not just against the purveyors of what you as a plaintiff think is an illegitimate operation, but in the case of the recording industry, the much ballyhooed campaign against individuals, was something that can be, the efficacy of that can be debated. It got a little hyperbolic at times. My organization, when it was very new, took advantage of the fact that those lawsuits were new and called attention to the fact that they really probably weren't a good way to make public policy or broad legal policy by suing 9-year-old girls who were honor students at Catholic schools being raised by single mothers in housing projects. If I could make this stuff up, I'd be a novelist, but it was actually true. Brianna Lahana and her mom were compelled, I guess is the word, to settle for about $3,000 that they didn't have. And we openly and admittedly and perhaps shamelessly, but I think also effectively, made much of reimbursing her mom for the fine, and that kind of put the issue of those lawsuits on the map, and that's where we wanted it.
Well, Adam, I appreciate you raising the issue of going after individuals versus intermediaries. One of the things that we want to speak about in this dialogue today is what role can intermediaries, whether it's advertisers, payment processors, telecommunications providers, search engines, technology companies play in combating piracy. And I wanted to turn to Howard and ask whether you've had a chance to think about some of the issues involving liability for carriers when it comes to carriers or communications companies rather than carriers for intellectual property.
Well, I'm glad you asked me that question, Drew. I have had a little bit of time to think about it. I think the all the issues that are presented by the growth of P2P and other distributed technologies puts internet service providers and communications providers generally in an interesting situation. One of the critical elements of the Digital Millennium Copyright Act was the safe harbor provision, and key to that debate, as a number of you in the audience will recall, was protecting intermediaries against liability because they were inadvertently, their facilities were inadvertently being used to host pirated content. And then the DMCA sets out a fairly complicated regime in which you can maintain your safe harbor in exchange for responding in a timely fashion to take down requests from content owners. But the regime that gave rise to the DMCA was one in which there wasn't a lot of distributed content. There wasn't the kind of peer-to-peer activity that, or cyber lockers that have come to characterize the world today. And that's put some pressure on the DMCA model, but not, I think, and as well on this whole notion of what it means to be a passive carrier or get a safe harbor. And it's not something, it's not a trend or an issue that's limited to the copyright infringement field. We've seen it arise in other fields where there's unlawful content, whether that's child pornography or whether that's other illegal content, internet gambling, illegal internet gambling, where the whole concept of passive carrier or safe harbor is under fresh review by policymakers, because in a distributed world, the ISPs, well, in any world, the ISPs are arguably gatekeepers. Sometimes that's a bad thing, right? If you ask people in the net neutrality debate, what about ISPs? They go, ooh, that's gatekeeper. And that's a bad word. But when you're trying to police conduct that is sort of widely distributed on the web, being a gatekeeper may turn out to be a good thing, because it's the last point of concentration, or the first point of concentration in a network arrangement. And policymakers are increasingly gravitating to that. And the content industry is increasingly gravitating to that, saying, ISPs or communications providers need to take a larger role in this endeavor of protecting against unlawful content, and specifically for this breakfast, copyright infringement. And I think there is a role. I think there's a shared interest between ISPs and content owners in deterring infringement. I don't think infringement is good for anybody. I was very disappointed, quite frankly, in the MPAA, RIAA comments to the IPEC earlier this year, in which they sort of accused ISPs of aiding and abetting piracy and benefiting from that. I don't think that kind of thing is really productive in the debate, because I do think there's a recognized shared interest by ISPs and content owners in going after meaningful, significant copyright infringement and dealing with it, whether that's through a notice program, a so-called graduated response program, whether it's through something like the Leahy bill, which I guess we'll talk about later.
Well, feel free to talk about it now.
I think there is a role that ISPs can play in dealing with and deterring copyright infringement. I mentioned graduated response. That, for those of you not following this is the concept where upon notice from a content owner, an ISP will pass a notice on to its subscribers saying, you've been alleged of infringement, stop. They don't stop, you send another notice and say, no, really, stop. And then maybe you send another notice and put up a pop-up or something like that. And what's controversial about that, and where I don't think this has been resolved, is whether the last stop is termination of the subscriber account, the so-called 3 strikes law, which has become popular in Europe and not so popular over here.
It actually has been enacted in France.
Right.
It's a 3 strikes legislation, and the tribunal needs to weigh in and sort of sanction the 3rd strike.
Right.
But it is kind of the death penalty for internet access.
It is, and I think that's actually a very hard, and I'll stop pontificating here in a minute. I think that's a very hard question. I think that there's a generally shared interest in alerting consumers and notifying them in a meaningful fashion. I think when you get to termination, certainly termination without a court order, I think people have different views on the appropriateness of that as a tool in deterring piracy. And I think we've seen the controversies in Europe over that, even with the tribunal. I mean, the first French statute did not include a tribunal. It was struck down. The second French statute included a review by a tribunal, and it's been upheld, but it's still quite controversial. Likewise, the Leahy bill, in which intermediaries, whether they're payment intermediaries
This
or
is
ISPs,
the Combating Online Infringement and Counterfeits Act, introduced on the 21st, after our last IP Breakfast Club, I'll have you know, and it received some degree of support, bipartisan support, but obviously Congress has not been able to do anything on it.
Just quickly on that, then I'll turn it back to you. On that, again, this is another way in which ISPs can participate in the shared endeavor. And in the Leahy bill, ISPs are asked for sites that are not registered by U.S. entities to block domain name resolution to sites that have been identified by a court as dedicated to infringing activities. And I think, again, there's some common ground there. I think in that instance, I think what's important is parity, that if one intermediary is going to be asked to do this, that there be some effort to make sure that all similarly situated intermediaries are doing it to avoid competitive problems. So I think there's a shared endeavor. I think there's a recognition that this kind of proactive activity on the part of ISPs can coexist with a reasonable safe harbor, provided it's all done in a kind of intelligent way.
Well, 2 follow-ups on your excellent comments there, Howard. One is on the graduated response. I mean, do you see ISPs being willing to go along with a graduated response program like we've just talked about? Isn't there an inherent tension in what an ISP wants to do and offer connectivity versus the notion of cutoff?
Well, I think it depends how you describe graduated response. I think if by graduated response you mean a French-style, 3 strikes policy, I think there'd be some considerable resistance to that. I think if you're talking about a graduated response program, which is more than simply passing notices on, which many ISPs already do, then I think there is some interest in that, in sort of ramping up the successive notices that are sent, being more involved, having customer service reps, having a phone number at the ready and explaining
Maybe you can
why.
throttle their bandwidth, huh?
Well, no one from the FCC is here, but we'd have to ask them about that, I guess. That raises other questions like, if you throttle somebody's bandwidth, do you affect their voice service? Do you affect their healthcare, online healthcare, things like that? But I do think, to some degree, yes, I think it could be done. And I think if you look at every ISP, and I think this is true for every major ISP, if you look at the terms of service or the authorized use policy, they all say, you can't use this service to steal content, and if you do, we reserve the right to terminate you under appropriate circumstances, the words of the DMCA. So I don't think it would be it's not a new departure for ISPs to be involved in this. I think it's how far down the road and what are the specifics. Obviously, it's being Washington always the issue. But I do think ISPs have already begun to pass notices, have already put their subscribers on notice, and it goes to whether you're going to move toward ultimate sanctions without court order, and I think people diverge.
Yeah, before I come back to the Leahy bill, Adam, why don't you weigh in here?
Just a very quick word, excuse me, to put this in context. It's very easy, for any number of reasons, in focusing on these kinds of policy issues, to think of it in terms of the first types of material that come to mind. Movies and music, of course, have been at the forefront of policymakers' consideration of these issues, and not for the least of the reasons that stars of movies and music have been used very effectively in the policymaking. However, as somebody who, until relatively recently, worked for a very major payments processor, and prior to that worked for many years on copyright policy on behalf of libraries, it is very, very easy to have very broad-scale collateral damage and economic consequence to over-regulation, and that's a general theme I expect we'll come back to here. When you're trying to calibrate this kind of stuff, if you're not thinking broadly enough about the full-blown implications for all potential ISPs, it's not just the Verizons and the Comcasts of the world who conceivably fall within the legal definitions of that. So if you are a Visa or a MasterCard, you're very interested or should be in these issues. If you're a library, you can be and should be interested. And if you're a university, you're especially interested in this. So it gets to be very complicated, and the temptation on the part of lawmakers to react, I'll give Senator Hatch credit for consistency over the years, to react, or I would respectfully argue overreact, to these kinds of problems is a very great temptation, but poses great danger.
We did invite financial industry officials to be here because we do appreciate that they're being asked to play this role. Lee, why don't you speak to some of these issues from DEMA's perspective? My interaction has been, you've been working obviously to sort out some of the licensing issues on the royalty side, but could you speak to the piracy and counterfeiting question?
Yeah, well, specifically with regard to the Leahy bill, and in echoing what Adam was saying, a lot of our concerns are the potential broad ramifications of that type of legislation. The same types of issues that Adam was talking about that would affect payment processors and libraries and other people are also of great concern to DEMA's member companies. I mean, by example, a good portion of DEMA's membership would, in one way or another over the last few years, might have fallen under the definition of what is a infringing site under the current proposed legislation. And just run through
some of the big members, Lee.
Well, our members include Apple and their iTunes division, Google, YouTube, Microsoft and their Zune division, various other internet radio companies. And at several points over the last few years, any number of our members have been pursued by copyright owners for what was alleged infringement. Now, my organization represents only royalty-paying, arguably legitimate services. We would certainly say that we're only, our services are only legitimate. Yet still there are those gray areas between copyright owners and services that are trying to innovate and deliver new and successful services and commercially desirable services to the consumers. And copyright owners aren't necessarily happy with the way those services are being developed, the way they're being priced, the way they're being marketed and promoted, and that gets you into a position where, because technology allows us to provide services like that that don't fit into the siloed existing understanding of what is a performance versus what is a download versus what is a sale, many of my companies get pursued by copyright owners, at least at the initial stage of their development.
This is the issue where the performing societies are going after you because they're considering it a performance, and then the reproduction rights holders are going after you because,
Right.
I mean, a stream could be and is both, obviously, and so
Correct.
your position would be make up your mind, right? I mean, you know,
Right.
it's one or the other. But as to the question of how you, what are the stance of your members on issues of you know, websites that are either clearly or close to everyone recognizes they're problematic? I mean, what does DEMA want to do about those?
Well, I think, you know, again, all of my members are legitimate royalty-paying services. So the fight against piracy is one that we join the content owners in. I mean, we're not in the business of supporting piracy. It hurts everybody, both content owners and legitimate distribution services of that content. But that gets to kind of the greater point that I wanted to make, which is when we talk about ways to combat piracy, I think one of the things that we have to look at is some of the reasons that this type of piracy, can occur and consumers, potential consumers, are driven to it. And I think a good part of that has to do with not only the technological development, but the lack of the licensing and the IP legal system to follow and to track expediently that development. So what you have, and you brought up a great example, which is only the most recent one, which is the fight over whether or not a download includes a performance. The problem that evidence is there is that we have a licensing regime that respects an old model that really countenances only the idea of a physical product and the ability to count how many copies of a CD or a Blu-ray disc or whatever get put through a distribution network. And the distribution network is now completely fluid. And so one of the ways that I think content owners can join with everybody in combating piracy is recognizing that that's the landscape that we live in now, and that you have to license models that actually move forward with the technological advancement and give consumers exactly what they want. They know that they can get the content now in a completely fluid environment. And so we have to stop arguing about whether or not it's a download or a performance, and we have to start licensing business models that don't necessarily try to characterize themselves as a download or a performance. We have to just start licensing business models that allow consumers to get what they want, when they want, because they know they can do that.
Let's go to questions in just a moment. Want to tee up, though, the issue once more of the Leahy bill, the Combating Online Infringement and Counterfeits Act. In June of this year, the Department of Homeland Security's Immigration and Customs Enforcement took action against 9 sites that were involved in pirated materials, counterfeit materials, and they replaced these with a banner that this domain has been taken down, and the bill that the Leahy bill has introduced would permit the shuttering of websites located beyond U.S. borders. Howard, you referenced the issue of making sure that your customers don't see these sites. And by the way, that right there on the screen is the logo of what was replaced on these sites in June. And so the question is, well, what else needs to be done legislatively to make this effective? Do ISPs need to take proactive action to avoid their consumers being able to access sites that have been seized by Customs Department?
Well, I think the most important thing that comes out of the Leahy bill and the Homeland Security experience is that it's important for there to be some court or government action. I think what ISPs are uncomfortable doing, and I think rightly so, is taking government-like action without some sort of government directive. And I mean, this is an issue that's not unique to the current copyright debate. It goes back to questions in the earlier days of the internet on whether information about web browsing is going to be turned over to the government in the absence of a subpoena. In fact, there was, just in the context of the cable industry, of cable ISPs, there was such confusion over this issue because of the broad language in the cable privacy provisions that there was a very little amendment to the Patriot Act in 2001 to clarify the rights and obligations of cable ISPs with respect to subpoenas from law enforcement, not in connection with copyright, but just generally. I think it's important that if there is going to be a role for ISPs in preventing domain names from resolving, or there's going to be termination of subscriber accounts, that be done in response to government order. And one of the things that I think is helpful about the Leahy bill is that the directives to ISPs or payment intermediaries or anybody else proceeds in the first instance from a court order determining that a website is dedicated to infringing activities. And we can debate whether that's the right definition in the bill about dedicated to infringing activities. But from my perspective, the important thing is that no one expects an intermediary to act in the absence of an Article III court looking at a situation, making a determination, and then having that enforced, if you will, through actions by intermediaries. I think that system can work. I think one of the issues that came up in the Leahy bill is what the subscriber sees when the subscriber goes to a website that's been blocked, whether that defaults to a government warning or whether that defaults to a 404 notice. And I think one of the things that I think the Leahy staff is considering is simply leaving that to the intermediary rather than having a directive where the government has injected a particular notice in a particular
But doesn't that go against what you've just said, that you want the government to tell ISPs to take action, and now you think it
No,
would be better
I don't
for
think
the...
so. No, I don't. I think it's important that the government tells us to take action, and then if we're acting pursuant to government order, I'm not sure it's a great idea for the government to tell us how to speak. I think those are two different things.
Okay.
Howard, I'm curious. I think the definition, the standard is any court order. In your view, since you've clearly looked at that, is that the right? Is that overly broad, or is any court order enough for the ISPs to take action? I'm just curious as we sort of walk through the bill.
The way I read the bill, it's a court order determining that a website is dedicated to infringing activities, and then a government directive through the statute that says if there is such an order, then intermediaries take the actions that are described in the bill. So any court order, I'm not sure what the thrust of the question is. I read the bill to be a court order related to the lawfulness or not of a particular website.
The earlier standards in the bill, right?
Adam?
Just a quick word, I'm eager for questions as well. It's the discussion of the details of these kinds of bills is absolutely critical, so in no way to denigrate that. When you're passing legislation, you got to get those details right, particularly where you're talking about essentially blacklisting a website, which is a rather creative concept, particularly based on in rem jurisdiction over a domain name. So points for creativity to the authors of the bill. My point is it's sort of the opposite end of the tube, which is in one level it's about messaging or semiotics or whatever fancy name you want to come up with, but the way we talk about these kinds of proposals and the way we talk about the environment into which these types of proposals are interjected is hugely important. For decades, literally, intellectual property policy in the United States has been disproportionately driven by statistical and other hyperbole. And I think that's probably true from any perspective. By
statistics or by hyperbole?
Yes. Sometimes they're synonymous, sometimes they're not. But we cannot afford, quote, by the way, we cannot afford to not act, especially when by some estimates, IP accounts for a third of the market value of all U.S. stocks, approximately $5 trillion or more. That accounts for more than 40% of the U.S. gross domestic product and is greater than the entire GDP of any other nation in the world, says Senator Hatch in support of GOICA. Now, perhaps Senator Hatch is right, but I'm guessing that when you peel away those statistics, you start to look at rather creative methodology from major content industries, historically movies and music, about the way to value IP. It's got a very high value, but on the opposite end of the tube, so do innovation industries like populate Silicon Valley, so do the educational institutions. There's a cost to overreacting, as I said before, and the way we frame the debate makes a big difference.
Are you ready for the GAO report? I thought you were going to go to the GAO report.
Well, yeah, we can go back to that as well.
The famous GAO report we talked about and got into fight last month. Next question here.
10 years ago, Dan Brenner with Hogan Lovells, 10 years ago, this discussion would have been around watermarking and the role that played in preventing piracy. Does watermarking no longer play a role? Is it an ineffective tool? Discuss.
I think technology should and can have a role in this. I think there have obviously been some bumps in the road in implementing watermarking and fingerprinting, but I do think there is a role for that. I think the movie industry, technical end of things, has been working on that. I think it's Drew's point at the beginning of this session about fresh thinking. I guess something that's 10 years old can't really be characterized as fresh thinking, but I do think that there are alternatives to individual lawsuits that need to be explored. Technology is certainly in that bucket.
I was just going to remark that I think it's interesting that, when we look at stuff like the Leahy bill, it shows a shift in the thinking about where to apply the pressure on these things, right? Adam talked before about, the rather infamous RIAA campaign against, various single mothers and dead people and legless, whatever.
Grandmothers.
Right, grandmothers, right. And so, watermarking, that was kind of an individually focused attempt, right? You're looking at the particular individual and trying to pursue them for their particular infringement. Whereas if you look at what's going on now with maneuvers to try to do things like block entire ISPs and the resolution of URLs, it's more of an outward-looking view, right? In other words, you're saying to yourself, maybe things like watermarking and fingerprinting and audio technology, audio identifying technology, and going after individual infringers is not the most efficient, and indeed may be an impossible way to accomplish the task. So maybe the better way to do it is to just kind of put up a block as opposed to individual choke points. And I think that's what you're seeing a shift in the way people look at this, and that's partly driven by the fact that the technology to do it on an individual by individual basis hasn't really been working. And so the idea now is let's just stop the flood, and it's more like a customs type border approach than it is let's go house to house and find.
And is that a better approach, Lee and Mike and Howard?
Well, it gets to the exactly what we're discussing. I think from a purely technological standpoint, I think it probably is a more efficient approach. Let's put it that way. It looks like it would probably be more efficient. But again, in terms of whether or not that's appropriate in terms of the application of IP law and whether or not you're going to be catching too many people in what may be a dangerously loose definition or what might be an overzealous application remains to be seen.
Well, I mean, I think they're not mutually exclusive, right? I mean, technological controls like watermarking and the like are not mutually exclusive than going after and trying to squeeze the revenue model of infringers. And I just think it's taken the IP community a long time to kind of understand the ecosystem that they're operating in. And I have to give them credit that they have come to the table and actually worked with, I don't know about your clients and such, but they've actually come to the table and tried to work with the ad networks. And I have to commend them for that. I've never, having worked at the association that probably supplied those economic numbers to Senator Leahy and Hatch, I've never seen the community. The content community is not one that likes to just take little bites at the problem. They like to try to take it all and put companies out of business and such. Here, I think what you see is a different approach, which is sort of a holistic. Here's this ecosystem. How can we put pressure on the bad guys? Whether we can properly identify who the bad guys are is going to be a point for discussion. But I think they also understand that when you look at the Leahy bill, to me, there's two questions. There's who ends up on the list, right? Is this domain good or bad. It's going to be black or white. And then you have this technological question of can you actually implement these solutions? And it seems to me easier probably for an ISP, but from an ad network perspective, just because you have a list doesn't mean then magically you can flip a switch and advertisements stop showing up on that site. So we need to work through the implementation as well, but they're certainly not mutually exclusive. Working with everybody in this ecosystem is actually a good approach, I think, for the content community.
Well, let's get some content community viewpoints.
Thank you for the content community opportunity. I'm Linda Blossbaum with the Warner Music Group, one of the members of the RIAA that did not necessarily provide all that statistical hyperbole, but just to correct, I think it was actually a 12-year-old girl, not a 9-year-old girl. So just to get all the statistical hyperbole correct for the record. But I'm very glad to echo what somebody was saying earlier, that we are talking in a more futuristic world. We're not talking about watermarking and suing 12-year-olds, but today's discussion is really looking forward, and I commend Drew and the organization, which does a really good job of kind of putting those on the table. But just to get back to both what Mike and Lee had said earlier about the willingness to talk about business opportunities. And Lee, I really was relieved to hear you talk about new licensing business models and how that can be done. And it's no secret that that my company and my industry and yours have often had very detailed negotiations about what that looks like. But I guess I would direct my question to Howard and his clients about licensing business models moving forward, because let's face it, I work for a public corporation. We're traded on the New York Stock Exchange. We have a fiduciary duty to our shareholders to make money. So as much as we can watermark and block and sue, we're going to go broke collecting on those settlements. So we are very interested in looking at those business models moving forward. What have your clients and your companies that it's in the ISP world thought about, actually business models along the lines of what Mike was saying with his clients in terms of, business arrangements with content companies? There are some very successful ones out there, but, moving forward, are there creative ideas that we can do, alongside of these cooperative graduated response programs?
Honestly, I've given that no thought. I don't have an answer for you.
None.
I don't. I mean, you can talk to my clients about it. I have not been involved in those discussions, so I'm not familiar with that.
And maybe your companies have, Adam. I think that's actually a pretty telling answer too.
Yeah.
Well, excuse me, I don't know why it's telling. I'm not prepared for the question. So it's telling. It's only telling about my preparation. It doesn't say anything about my clients.
Did you want to comment, Adam?
Yeah, briefly. I have no current clients in this space, and P2P United, as I indicated, kind of went the way of the buffalo with the Grotster decision. However, it was a central organizing principle of P2P United to promote exactly the premise of the discussion we're having at the moment, which is, from a pragmatic perspective, like it or not, the reality of distribution of, at that time the debate was primarily about music and movies, is not confinable. And the question about technology was a great one. It's a specific control technology, but the role of technology in this debate is not just about controls, it's also about facilitating markets. And P2P United was, on a good day, disagreed with, and on a bad day, derided, when we stood up and said, look, we know compulsory licensing has a nasty sound to it, so let's name it IRV, which is a much friendlier thing, and let's just have an IRV discussion. Now, technology has moved on, happily, in all kinds of important and useful ways. And I'm not suggesting that there are no market models out there that can't and shouldn't be predicated upon individual negotiations between relevant parties. But where you've got microtransactions going on by the billions, and where we now have technology that facilitates payments for microtransactions in the billions, why in the world aren't we talking about a model that, at least, and I'll be deliberately hyperbolic for a moment, uses technology as if it were a magic wand to suddenly wave it over this environment and turn everybody who's currently an infringer and a pirate into something called a customer. Now that was
a paying customer or
sure,
a non-paying customer?
A paying customer, exactly. And with micropayment transactions and a premise that, and I think there is some significant study data there to indicate this, people are not inherently criminal. If they can pay, and they can pay easily, and they can pay fairly, they will, and they will gladly.
Well, Lee, I mean, one of your most famous members, of course, Apple, is a years-old story, of course, has really transformed the music business with iTunes. Could you speak at all about any thoughts that they had about what it takes to transform a freeloader into a paying customer?
I honestly, and this only goes to my preparation here, it's not a telling comment. I really can't speak to, Apple's individual business plan, the way they came up with the iTunes, the pricing, the model, or whatever. And I really don't know what they, as a company, specifically do to try to convert what might be a illegitimate consumer of media to a legitimate and paying consumer of media. But I will say that as a general principle for what is the basic business types that we represent at DEMA, that is a struggle that we deal with all the time. As I said earlier, we're at war with the pirates as well, because they're taking business away from us just as they're taking business away from the content owners whose content we provide. And again, I think part of the problem that we're talking about here, and if you look at it, it just comes down to economic strata, right? I mean, historically, music and other types of media like film were economically scarce, partly because of the physical nature of the distribution model. And the technological advancements that we've seen over the last 10 or 15 years have made them physically and economically not scarce anymore. But again, we have a copyright paradigm, and we have a set of business models that is predicated on having a physically scarce good. And those two things are just not meshing, right? And that's really the issue. So how Apple actually deals with that, I'm not at liberty to say, but as a general principle for DEMA member companies, that is a very kind of grand way of talking about the struggle.
And I'll just make one comment. Ironically, I guess, that pirates don't tend to pay a lot of money. They don't tend to be real good customers, except for our industry where eyeballs are what counts. But so I guess our industry does make money, but the reality is we're not interested in that revenue stream, and so we're committed to trying to shut off that advertising. It's not as easy as just flipping a switch, but it's also not a big enough part of our industry. We understand that marketers don't want to be on certain types of sites, and so we're committed to trying to solve that problem.
Jim Berger with Dow Lones said, I knew Linda was smart when we hired her years ago. And that's really the question here, and that's the next panel. And part of the problem is the whole music licensing scheme and the Copyright Act is a mess. But the question for Howard is, it's very nice that the ISPs want to work. And I'm glad, Drew, you mentioned the French effort called La Dopie, because their headlines today in Paris are, La NSA n'aime pas la Dopie. NSA doesn't like Hadopi. So here's what's happening, and I want to know how you're going to cooperate. People are going to encryption. They're going to ways they're not going to be detected. And so how do you deal with that? Or maybe you should get prepared and help Linda, because I think that's the thing that's going to solve piracy, is selling the content and getting that revenue stream and giving it to the content industry, not necessarily shutting it off.
Well, I guess with all due respect, I would put it back on the content industry and on Warner Music and on I guess not on your cable clients at the firm, but other clients in your firm, to come up with business models that people find attractive. I mean, well, that's great, because I think that's where the burden really lies. I think the ISP industry, obviously, and not just the cable industry, recognizes that it benefits most when you've got a lawful way to buy content. Whether it's the ISP industry's responsibility to develop a business model, which I would dispute, or whether it's the ISP's role here to work with creative folks in the content community who come up with intelligent business models, which I would endorse, I guess is the question. But I'm puzzled, I guess, by both of your questions, to the extent, I'm sure I'm mishearing this, that it's somehow the ISP's responsibility to devise business models for the content industry. Okay, well, I'm missing the point then.
Well, let me come back to the DMCA and the passage of the DMCA. I mean, we had a different industry 12 years ago. I mean, America Online was, of course, a major player in the DMCA discussion. And were they a content company? Were they an ISP. They were clearly both. And I think that maybe, let me phrase the question this way, Howard, is that do you think that ISPs are on the course to wanting to be more editorial in their view of the world? Back to the question of, do you show a 404 screen or do you show the government's screen? This site has been taken down. Where do you think that ISPs are going to want to end up being?
I'm not sure I understand your question either, Drew.
Do you want to be a carrier or do you want to be an editor?
Well, I think ISPs are both in the same way that communications providers of content, whether they're cable operators, broadcasters, or ISPs, have been both. I don't think that's anything new. I think when they function as providers of connectivity, they are passive carriers, as recognized by the DMCA and a variety of other statutes. When they put up their own websites as part of the panoply of content that's available to customers, they're editors. The same way that cable companies have long been held to be editors, even though they're providing access to third-party content. I guess what I would consider the somewhat minor issue of what screen an ISP puts up when it's acting in response to a government order to disable access to a particular site doesn't strike me as raising necessarily the sort of cosmic issues that are pregnant in your question.
No, I'm not trying to suggest that there's big issues with that issue. I think that there's just a question of, is the industry evolving towards one where ISPs want to get involved in those kind of decisions?
Well, when you say, what is that, I guess, what do you have, you must have something in mind. When you say ISPs involved in editorial decisions, what does that mean?
And maybe it's not a question for ISPs, maybe it's a question for web portals, for search engines, like Yahoo, like Google. Are they going to be involved in changing the results so as to exclude copyright infringing material from searches?
Well, I think I'll make the point that I made in my earlier remarks. I think ISPs are prepared to be involved in that. That's not the positive business model, I think, that Linda is asking about. I don't know the answer to that question. But I do think that ISPs are prepared to be involved in response to government directives. I think where ISPs are uncomfortable is in taking on what you've described as editorial functions. I guess I would describe in the context of this breakfast enforcement functions, really, more than an editorial function.
Right.
I think ISPs would be uncomfortable undertaking enforcement actions against customers, at least at the end stage, without some government directive. The same way I think ISPs should be appropriately reluctant to engage in blocking or eavesdropping on their customers without government directive. And my point is only that there are things that ISPs are prepared to do short of termination, short of blocking, in cooperation with the content community in order to, I think, pursue this shared objective of deterring piracy. I think that at the extreme ends of that spectrum, there are things that can't be done by ISPs. One, ISPs can't devise a model that will encourage people to buy lawful content. I think that's really, in the main anyway, on the shoulders of the content industry to do, and I think history has demonstrated they've failed spectacularly at that so far. And I hope I anticipate they're going to get smarter about it. And I think at the other end is enforcement with the ultimate sanction of termination, which I don't think ISPs should be engaged in or can be engaged in.
Okay, no, thank you.
Drew, just to answer, your kind of follow-up question was whether search engines or portals should be, and it's certainly they don't want to be the policeman of the internet, but to the extent that there's a legal process in place, such as search engines participate in DMCA notice and takedown, and that's an appropriate mechanism for search engines, and I don't think that's the driver anymore. From a publisher perspective, whether you're a portal or even an Apple with I've got my my iPad, and Apple's not going to allow in their app store, a clearly infringing app or something that says, hey, download the latest, Viacom protected content, because we know where that goes. So certainly there's some responsibility there, and they certainly participate in the process to protect content.
I just wanted to make an observation. It's a half a degree off, but while we're talking about ISPs as kind of like this holistic group, it's over the last 18 months or 2 years that we've watched Comcast try to merge with Universal at the same time that Time Warner spun off its cable division. So at least in terms of the way an ISP looks at the respect of content and their view of content, obviously there's not, we don't have a uniform view there, right? I mean, they're going in opposite directions for whatever are unique business reasons, and it's interesting, to see that there's not a uniform direction there.
Bob Schwartz from Constantine Cannon. Back on the Leahy bill, and this might get into the realm of mind reading, which nobody's ready for, but there's been some talk of adding private right of action to the Leahy bill, and what questions that come to mind would be by whom, against whom, and for what? And I wonder if anybody has any speculation.
I don't think, I've heard that too, but I don't think anybody on the panel has been the proponent of that. There may be others in the audience who are and can speak to that.
I think it's been discussed more in the House version than we've sort of been waiting for. I mean, I agree. I think that's kind of a non-starter for most industry players.
Right.
Certainly most industry players represented up here.
Yeah.
Right.
Great, we have a
the
question.
same questions you do.
We have a question here.
I'm Jim DeLong with Digital Society. I just want to make a comment on the business model idea and that the companies have been remiss on this. And that is, while they've certainly been slow to figure out how to use the internet, the fact is there's no such thing as a business model that isn't predicated on some defense of property rights. I mean, you cannot sell content, micropayments, or any other way without having some property right. You cannot run an ad model without some way of defending your property rights, as the newspapers are discovering, where their content is being commoditized and everybody races to put it up and attach advertising to it. And so I think, Howard, you got the cart before the horse here, and that is you have to figure out some way of protecting the property rights, and then the business models will follow, or rather it's an interactive process. But you can't simply say we don't have to protect property rights and therefore it's the content company's
I don't think I said
responsibility.
that. I missed that part if I said that. I don't think I said
Well,
we didn't. I think I said just the opposite. I think I said ISPs are prepared to step up and work on protecting property rights. What I said was I wasn't aware of whatever negotiations might be going on between ISPs and content owners, not that there weren't any going on.
I mean, the question comes back to whose property right? I mean, it's the property right is the content holders, and you're saying, as I hear it, bear the burden of coming forth with a plan that works and makes sense from their perspective and the perspective of the carriers, ISPs.
No, what I was saying was I was making a much more modest point, which was for some proportion of people who go to pirate sites, the absence of attractive lawful sites with reasonable payment plans and scope of right drives them there. Not to everybody. There are obviously bad people who are just going to steal if they can steal. That was my only point. My point wasn't that it was the content owner's sole responsibility to protect property rights. My point was just the opposite. My point was that ISPs, I think in more recent years, have expressed a willingness and an interest to share responsibility, notwithstanding their historic status as passive carriers without direct responsibility for infringement.
Adam?
Yeah, one sort of small point. Again, it may seem to be semantic, but I would suggest it really isn't. Property is about as loaded a word in law as you can get to. And when you try making policy about property, and what springs to mind when the word property is used can be hugely influential for good or ill in the debate. And I say this because when you broaden out the discussion to look at ACTA, the
Anti-counterfeiting trade agreement?
Yes, the alleged trade agreement, which some scholarly folks would argue is really a very significant potential rewrite of intellectual property law, kind of through the back door going on. When you look just at the distinction between trying to lump copyright-related issues with counterfeiting of physical goods and the confusions and potential overbreadth that results in the type of actions that you wind up with. It's very important, I think, for us to find, and I've said this for 10 or 15 years now, why stop now? It's very important for us to find, jokes about Irv aside, new ways to talk about this. what the property that you're defending may or may not need defending if, for example, there's a compulsory license system and it's no longer an infringement for somebody without prior permission to use something as long as they're participating in that micropayment system. So the words count, and the labeling of parties and their orientation is also subject to this dictum. With one very quick war story, if I may, I was in many of the rooms when the DMCA negotiations were going on, and that wasn't hard because, believe it or not, under Representative Goodlatte, there were actually public negotiating sessions. So picture an audience in a congressional hearing room with a very long table at the front around which the designated stakeholders were seated and grouped initially according to the access providers, the internet service providers on one end of the table, the content community on the other end of the table, and initially at least companies like Time Warner sitting in the middle as the hybrid group, because it was recognized even then that not any one of these stakeholders was completely pure in the sense of what its orientation to the emerging businesses were. So the words count, and it's time for us to find some new ones, as well as new business models.
Well, for the last few minutes that we're here together, let's just come back to the core question, which is we are talking about intermediaries. We are talking about payment processors, advertisers, telecommunications companies, search engines, financial institutions, media companies, what role they can play. And I think that one key point we're getting is that the roles that they can play may be different from what they should or should be required to play. They have some degree of flexibility and freedom. And Mike, to come to a point you're saying it's not really even in your interest, to advertisers' interest, to stop putting advertisement on sites that are associated with piracy. Yet that's what you want to do. You want to keep them off there because I guess either the reputation or other reasons.
Yeah, for us, our clients, it's in their interest, right? They don't want to be associated with illegitimate sites, and so ultimately it does make sense. Does it mean that there's a transition period where somebody loses, a few dollars because they're taking domains and sites, clients of theirs, out of their network? Absolutely. But long term, it's for the health of the overall industry, and we recognize that. It's one thing to kind of bump along for years and say, yeah, we're kind of a nascent industry, don't really pay attention to us. But I think those days are over. I mean, online advertising accounts, it's a $25 billion a year industry here in the U.S. alone. So we have a responsibility.
Do any of the panelists think there are other vehicles that intermediaries either want to take advantage of or don't, like Section 230 of the Communications Decency Act, for example, that offers Good Samaritan exemption from liability for players who do, that was obviously in the context of child protection, but I think it could apply in intellectual property protection too. Anyone have any thoughts on that question?
I want Howard to get all the immunity provisions for my clients, and he gets for his.
Great. Well, I think it'd be useful if each of the panelists would be willing to offer 30-second concluding remarks on what they think is the future for finding solutions to problems of copyright infringement. We have talked about there's maybe a different approach now going after domain names with the bill we've talked about, COICA, as well as other methods. But what are some of the big picture thoughts that each of you have about the way, where to be looking for these solutions? Start with you, Howard.
Sure. I think if you go back to the beginning of this breakfast or rerun the tape, you'll see that my point was and remains that I think ISPs recognize that have long acknowledged and recognized and made the point that piracy is not good for anybody in the ecosystem. I think what's new is that ISPs are willing to, and ready to step up in a more proactive way to help deter piracy. And perhaps that's what was maybe that's what was meant by this question about business models. But regardless of the label, as I said at the outset, notwithstanding their historic role as passive entities, given safe harbor by the DMCA or the Good Samaritan provision of Section 230, ISPs recognize that they are part of the solution, and I think are willing to step forward to do so, to be part of the solution. I think what's important in that world, though, is that everybody else in the ecosystem also step forward. That means more creative, lawful access to music and movies. It means competitive neutrality and parity in the way that intermediaries are treated. So it's not just one intermediary or one set of ISPs or ISPs to the exclusion of search engines. It means that if we're going to move away from a regime in which the intermediaries are without responsibility, that the responsibility that's assigned be done so in a way that makes sense from a technology standpoint as well as from a competitive neutrality standpoint. And finally, that there remains an important role for the government. ISPs and other intermediaries are not government entities. And ultimate enforcement responsibility, or at least ultimate enforcement authorization for intermediary action rests with the government, should rest with the government.
Thanks.
One thing we haven't talked about is the recent intellectual property report that the U.S. government put out in the task force that's connoted there. It's a rather, kind of sweeping effort that's clearly going to be ongoing. Let me just read something very brief from the conclusion of that.
And we did talk at length about this last month, and
Great.
Backdrop for the whole series, but please.
Great. To summarize then, Victoria Espinel, the Intellectual Property Enforcement Coordinator for the government, in her letter to the President as the last of her 6 points as to what the effort was about, said that we will improve data and information collection from intellectual property related activity and continuously assess domestic and foreign laws and enforcement activities to maintain an open, fair, and balanced environment for American intellectual property rights holders. Well, I leave you with the thought that the public, that creators who will become business people and copyright owners, while they may be dependent upon exceptions to copyright law now, and it was argued certainly when I was debating this with folks on other kinds of panels, that they weren't really rights holders, that they had some privileges, but that's different than the copyright holders themselves. Let's get beyond that in answer to your question about where do we go from here. Let's change the discussion so that whether it's a lion lying down with the lamb image, or you simply want to acknowledge that we don't like sitting across the table from people who used to rip us off, but it turns out that they keep getting billions and billions and billions and billions of more eyeballs, so let's monetize it. It's time to move beyond those old paradigms. Not junk property law, not junk intellectual property law, which I would argue and did is distinct from traditional property law of hard goods and should be. But let's see if we can go forward taking advantage of the technology to monetize transactions that are now outside the law. You need a whole lot less enforcement if you have a whole lot less fewer crooks because you changed the models and the definitions.
Thanks.
No, I agree. I think going back into the traditional, IP arguments back and forth and license this, license that, and let's tax, blank cassette tapes and CDs and things like that are not, those kind of historic discussions are really, really difficult. I just would urge the content community to sort of embrace the technology and the ecosystem. 12 months ago, I was a home subscriber to the Washington Post, and whatever that cost a year. And then I decided it wasn't really worth it, and I'd take the Metro in every day, and I started picking up the Express, which is the free truncated version, and I started reading that. And I'm sure then it wasn't worth the $150 or whatever a year I used to pay for my home subscription. And then when I got my iPad, the Wall Street Journal app was so compelling, the content was so rich, and it was so well done on this new media, then I now subscribe to Wall Street Journal. So it's a bit of a story in changing media consumption and habits there, but it's really kind of a success story for the newspapers and the content community to embrace the new ecosystem and find ways to monetize. So I think that's helpful, and I think we stand ready to sort of work with you on the policy and legal side to try to work within the ecosystem and within the business model to try to protect content to the extent possible.
Thanks.
Yeah, I think in closing, we've talked a lot about piracy and the need to protect, at least on some level, individual property rights and intellectual property rights. And I think ultimately that discussion really gets down to, and Adam kind of touched on this, it gets down to appropriate pricing points and appropriate business models. The fact of the matter is there's all kinds of stuff that can be pirated, not just as a result of the technological developments on the internet, although there are those. You know, you can pirate books, you can pirate movies, you can pirate music. But the debates keep centering on, again, what I think are historically, economically rarefied items, right? So you got pharmaceuticals, you got music, and you have movies. And I think the role that the government can play in helping us to get beyond these problems, and I think, again, one of the problems is not just that piracy is available, but that pirated sources of these materials are more attractive as a result of outdated pricing and business models. And the way the government can help us with that is by finally looking at a better than 100-year-old regime of copyright and intellectual property laws that respect a world where the only way you could get a good from somebody else is they put it on a big wooden ship and it sailed for 3.5 months across an ocean to you, packed in salt. The fact of the matter is that these markets are completely fluid now, and what we need to do is update our legal paradigm to respect that, so that these types of business models that Adam was talking about, that allow what would otherwise be a non-legitimate consumer to become a legitimate consumer, are not hampered by legitimate businesses trying to get licenses so that they can do that, and they're stopped from converting potential pirates because the pricing model is too high, and without billions and billions of dollars of VC money, they can't run, launch, and maintain a business.
Well, before we thank our sponsors and our speakers, I just want to remind everyone about the next Broadband Breakfast Club next week is on evaluating the broadband stimulus. And then for the next Intellectual Property Breakfast Club, we'll be talking about approaches by internet service providers around the world to copyright infringement in November, and then China and intellectual property with the Chinese IP attaché in December. And just one final word about our sponsors. We launched this series in May as a trial balloon for 3 months, and we're happy with the reception that we had, and decided to go forward for a whole year. And what our goal is, as our goal has been with the Broadband Breakfast Club, is to bring all parties and players together in the intellectual property community, the communications community, the technology community, so that we can think about fresh solutions to these issues. So please join me in thanking our sponsors, the National Cable and Telecommunications Association, Public Knowledge, and of course our speakers, Howard, Adam, Mike, and Lee. Thank you again for being here.